Guys, Attorney Jesse Arana. Today we're going to be talking about what do you do if you are pulled over in California or stop at a checkpoint and are now the subject of a DUI investigation. Very scary, I know. What comes into play is actually your Fourth and Fifth Amendment rights. Under the Fourth and Fifth Amendment rights, you can do the following. So let's explain this by step. When you're pulled over, the first thing the officer is going to do is go to your driver's side or passenger side, ask for your license and registration, and kind of stick his head inside your window to get a whiff of the inside of your car and a view. They're not trying to smell your clothes and smell if you have any BO. They're actually trying to smell any type of alcohol or marijuana. Why? Because they want something that's called cause. That's just a fancy word for they want additional reasons, justification to order you to get out of the car. At this point, the officer is going to ask you, have you had anything to drink? Have you consumed any marijuana, etc.? The Fifth Amendment of the United States Constitution says you can tell the officer the following: I respectfully decline to answer your question. That is not evidence of guilt. That cannot be used against you at all. The officer may say, well, if you have nothing to hide, then why don't you just answer that question? That is a tactic. Do not fall for that. You have to stay firm and say, respectfully, sir, I decline to answer your question. It is not a good idea to lie. So if the officer asks you, have you consumed any alcohol? And you did, do not say, I did not consume any alcohol. The reason for that is because that can be used as something called consciousness of guilt. What does that mean? That means that if your case goes to trial, which a lot of my cases do go to trial because I'm a trial attorney. If your case goes to trial, the prosecutor can tell the jury, ladies and gentlemen of the jury, you heard evidence that this person did consume alcohol. You also heard evidence that he said, no, I did not consume alcohol. Why? Because that is consciousness of guilt. He knew he was guilty. That is one of the reasons why it's not a good idea to lie. What is a good idea and what I recommend you do is instead invoke your right to remain silent by saying again, respectfully, I decline to answer your question. If the officer still orders you out of the car, you have to get out of the car. Okay, it is not a good idea to stay inside the car. There is no law that protects you from staying inside the car. If he says get out of the car, get out of the car. Okay, you don't want additional officers to show up. You don't want them to bring a crane and try to pull your door out. That's not a good idea. So if he tells you to get out of the car, get out of the car. Once you're outside of the car, the officer is going to ask you a series of questions known as pre-field sobriety test questions. These questions are going to be things like, how much did you drink? Where were you drinking? On a scale from 0 to 10, how do you feel the effects of the alcohol? Where are you going? Etc. Again, under the Fifth Amendment right, you actually can say, respectfully, I decline to answer all of those questions. I respectfully decline to answer your question, etc., whichever way you want to say it. But you do not have to answer those questions. Under the Fifth Amendment of the United States Constitution, you can actually say, I don't want to answer those questions. And that's what I recommend you do. After these questions, the officer is going to move on to what's called field sobriety test. On another episode, I'm going to explain the details, the levels, the steps that an officer takes in doing a DUI investigation, so go ahead and check that out. Right now, we're just going to be talking about your constitutional rights, okay, and what you should do if being investigated for a DUI. So, during these field sobriety tests, the officer is going to ask you to follow the tip of his finger or the tip of his pen from side to side without moving your head. That's called the horizontal gaze nystagmus. He's also going to ask you to do the walk and turn, the one-leg stand, maybe some additional tests, one called the modified Romberg. That's where you stand still, put your hands to your side, tilt your head back, close your eyes, and count 30 in your head. And also to provide 2 breath samples through what's called the preliminary alcohol screening device. All of these tests are going to be demanded from you. They're supposed to be requests, but they're going to be more of a demand. The officer is going to say something like, I need you to do these, you need to do these, etc. All of these tests are done before you are arrested. At this point, you can tell the officer, I respectfully decline to do any field sobriety test. It's really important. You only have this constitutional right if you are not a minor or you are not under DUI probation. If you are a minor or on DUI probation, these protections do not apply. So that's really important. So anyways, going back to our explanation. So after the field sobriety test questions, the officer is going to ask you to do some field sobriety test. And at this point, what I recommend you do is say, I respectfully decline to do any field sobriety test. After you decline to do any field sobriety test, the officer is going to have to make a decision. Am I going to arrest this person or not? And it's really important to understand the officer has to have enough reason to arrest you. What evidence of a possible DUI does the officer have? Not much, if anything at all, right? The officer asked you, have you been drinking? There's no answer there. The officer asked you pre-field sobriety test questions about your drinking pattern. No questions, no answers there. And the officer asked you to do some field sobriety tests to see if you are showing objective signs and symptoms of alcohol impairment or that you are impaired by alcohol. No results there. So what evidence, if any, does the officer have that you are a DUI? Not much, right? Assuming that the officer still decides to arrest you for a DUI. At that point, the officer is going to demand from you to provide a blood or breath sample. He's going to say something to the effect of, under California implied consent law, you have to give me a blood or breath sample. Which one do you want to do? It gets tricky here. Under the Fourth Amendment of the United States Constitution, you still have a constitutional right to say no. You have a right to say, no, I'm not going to give you a breath sample because that is a search of your person. Or, no, I'm not going to give you a blood sample because that is also a search of your person. But this is where it gets tricky. If you do that, you do have to understand that you run the risk of DMV, yes, the beautiful Department of Motor Vehicle, suspending your driver's license for 1 year. I repeat, 1 whole year. That's 1 year without a driver's license, and you won't be able to get a restricted driver's license at all during that 1 year. It is known as a hard 1 year license suspension. If your license is suspended for 1 year, that includes any commercial license endorsements and any endorsements at all. So if you have a Class A, a Class B, or an M1 motorcycle license endorsement and your license is suspended for 1 year for quote-unquote refusing to submit a blood or breath sample after being arrested, all your endorsements will also be suspended for 1 year. So that's something you're going to have to decide whether you can afford that risk. Now, if you can't afford that risk and you say, no, I'm not going to give you a blood or breath sample, then the officer has no other choice but to ask a judge to sign a warrant for your blood. In this application for a search warrant, the officer has to explain what evidence there is of you being a DUI. Again, what evidence is there? Not much at all. There is no admission to drinking. There's no admission to any type of drink pattern. There's no performance or failed performance in field sobriety test. So there isn't really much evidence that he can put in that application for a search warrant. If that application is submitted to a judge, the judge will review that application and either say yes or no to the request for a warrant. If the judge says yes, then you'll be taken to a hospital or any other facility where your blood will be drawn by it's supposed to be drawn by a professional, such as a phlebotomist or a nurse. If the judge says, no, I'm not going to sign your warrant, well, that's a good sign, because that judge is essentially saying, I don't believe there's enough evidence to believe this person was driving under the influence of alcohol or drug or a combination thereof. Now, going back to that tricky scenario, if you cannot afford to gamble the risk of having your license suspended or revoked for 1 year for refusing to provide a blood or breath sample after being arrested for a DUI, then you have to decide, do I want to do breath or blood? What I recommend you do is provide a blood sample. Why? There's a lot of different defenses that apply to blood sample versus breath samples. For one, we can challenge the credentials of the person who withdrew your blood. For example, that person has to be a phlebotomist, a nurse, or another person licensed to withdraw a blood. It cannot be just a simple lab technician. Another defense is whether your blood was drawn in a medically approved manner. If you are diabetic or taking anticoagulants, that's a fancy word for blood thinners, they're not supposed to draw your blood because there's a risk that you can bleed to death if they withdraw your blood. So that is called challenging the blood through a medical approved practices. There's other defenses as well that apply to blood, which I'll be talking about in another episode. So if you guys have any other questions about what to do if pulled over or at a checkpoint and are now being investigated for a DUI, by all means call Law Office of Jesse Arana at 562-392-8209. You can also visit my website for more information, www.jessearanalaw.com. All right, guys, be safe.